All right, so the topic this afternoon is global asset protection for a dangerous world. And as I mentioned, you can sign up for some of the handouts. This is really what I'd like to do over the next 45 minutes. I'd like to talk about what is asset protection, why do we do it, what risks are we protecting ourselves from, what are the benefits of international asset protection planning, and what are the most common structures to achieve asset protection. And I know for some of the folks in the room, you have a really solid background. I mean, I always talk to at conferences with people. They'll come up to me and say, you know, I set up my first offshore trust in 1960, and what were you doing then? And I say, well, I wasn't in existence then. So I recognize that some people have a lot of experience, but I guarantee there's also some people right here in the audience that have never heard or thought about this topic. So I like to say I feel a little bit like Elizabeth Taylor's sixth husband. I know what I'm supposed to do. I just have to figure out how to make it interesting. All right. So I'll try to make it interesting over the next 45 minutes, but it might, in some cases, seem a little bit simple. I want to make sure that everybody's on the same page. So what is asset protection? It's simple. It's protect what's yours. Most of the speakers that are going to get up and talk to you over the next few days are speaking about, investments, how you can grow your wealth, or they're talking about lifestyle. Where you might want to get a residency, where you might want to live, where you might want to spend time. And those are all great things. Investments I like to think of as the offense. Asset protection is the defense. It's the other side of the coin, protecting what is yours. Now for some people, we just had a little primer on this in the last discussion. For some people, it could be a very, very complex structure. And for some people, it could literally just be taking your 16-year-old daughter's credit card away from her. Okay? Those are all asset protection techniques. All right? I mean, the one joke I heard the other day, I thought it was pretty good. The police find a credit card that a organized crime had acquired and was using about $700, $800, $900 a month in illegal charges. So they contacted the person, happened to be a doctor, and they said, "Doctor, we found this credit card, and we wonder why you never reported it stolen." He said, "Well, actually, it was my wife's credit card, and whoever stole it was spending a lot less than she was." So, anyways, the point is that asset protection is really all across the board, okay? I also want to mention what asset protection is not, because particularly when you come to conferences like this, people will always, get me at a cocktail party in the corner and say, okay, so how do we do it? How do we really do it, Nagel? And what they really want to know is, how we can make our money disappear, how we can not pay any taxes, how we can, whatever their ideas are. And I want to just say, it's not a scheme to evade taxes, okay? We live in a very, very transparent world. A friend of mine is a banker with a pretty large U.S. bank, and we were talking about this issue, and he said, "Joel, if you walk into our bank and you say, send $100,000 to, fill in the blank, Panama, Nevis, Belize, Liechtenstein," he said, the report that we fill out is simultaneous with the wire transfer. So normally, the U.S. government knows about that transfer before you've even walked out of the bank. That's how real-time these things are, okay? And, the days of, walking around with money in briefcases, I think, you still see it in the movies, but it's really long gone. The last one I can remember, this was 7 or 8 years ago, and I really wish I had a picture of it. There was a bank in Anguilla, and it said, "We accept cash deposits," and then underneath it said, "subject to a 17% service fee." So what they're telling you is, if you deposit $100,000 in their bank, $83,000 is going to show up on your ledger. Now, does anybody think that's a good idea? Anybody? I mean, what they may as well have just had a sign that said, "We launder money," right? Because, who else would consider depositing cash into a bank and losing 17% of it? Nobody. And that bank's not around anymore. So, those days are really over. We live in a very, very transparent world. And occasionally people will come to me and say, "How can I move money that nobody's going to know about it?" And, the answer is really, truly, you can't. I mean, most banks now, if you do even a fairly small transaction, $3,000, $5,000, $7,000, it's gonna trigger reporting requirements. So, all right. Now again, I come from a rather large family and have a big family myself. The folks in the room who know me know that I have 7 children. Very happy that my oldest daughter Mary's in the back of the room. She flew here from Brazil just to see her dad for a couple days. So I'm really happy to have her here. But I think sometimes that children's stories and children's analogies can really drive home points in a simple way that people understand. Now, this picture, you see that these children, are playing hide and seek, but in the end, they think that you can't see them because their eyes are covered. You with me? Except the little girl on the end, you can see she's kind of peeking out a little bit, but you can't see them because their eyes are covered. And that is the mentality that a lot of people use when they go into the offshore world, okay? It's not really a game of hide and seek anymore, right? I like a different children's analogy, and that's show and tell. That doesn't mean we're going to go up to the mountains and tell everybody under the sun that we have an offshore structure and a trust and this and that. No, but when I say show and tell, what I really mean is that if somebody comes to you and whether it's a plaintiff's attorney, government investigators, whoever it is, you should be able to plop down your structures right there on the table and say, this is what I did. It's perfectly legal, moral, ethical. If you think you could go after the assets, have at it. I'll tell you one quick story. This was in the very earliest days of my practice. I was representing a physician who sold his practice to the University of Pittsburgh Medical Center for about $3 million, a little bit less, but almost $3 million. And he paid about $1 million in taxes and moved the other $2 million into an asset protection trust. And as it was, the trust was set up in Belize. And about 4 months after the sale went through and the taxes were paid and the money went into the trust, his longtime nurse brought a whistleblower case against him saying that he had defrauded Medicaid and Medicare. Now you'd say, well, why would the nurse do that? Well, the way the law is written, the whistleblower gets a substantial amount of any money that the government recovers. But the thing is, defrauding the U.S. government is not just a civil matter, it's a criminal matter. So, unfortunately, both a civil and criminal process was started against my client. And, several months into the process, in open court, the criminal judge threw the case out and said not one shred of evidence had ever been shown that my client had done anything wrong. Now you're going to say, well, if the criminal case was thrown out where the burden of evidence is so high, what about the civil case? Should that be thrown out too? Maybe, but that's not how our legal system works, right? Everybody has their day in court. And in this case, the woman had a law firm from Texas that represented her. If you can't sleep at night and you have on late night TV, they say, no fee unless we get money for you, right? So she'd hired this firm that specialized in this kind of whistleblower case, and the case continued on and on and on, until finally we had a deposition one day. And a deposition is an official court proceeding, but instead of it being in a court, it's in a boardroom, usually of one of the law firms. But you still have to swear to tell the truth, the whole truth, and nothing but the truth. And in this particular deposition, they were asking my client about, what happened to all the money, right? I mean, they started off with some small talk about where he went to medical school and what practice area he had. But eventually they came to the one question that they really wanted to know. And it was the reason that there were about 10 people in the room. Dr. Jones, where did the money go? Because it clearly wasn't in his bank account. Sure, they had looked at that. And he said, well, we paid $1 million in taxes. We transferred the other $2 million to an asset protection trust, and the trust is in Belize. Show and tell, right? Here's the documents. Here's the telephone number for the trustee. And I noticed a lot of whispering between the other lawyers. They asked if they could take a 5-minute recess and confer with their client out in the hall about the situation. We said, sure. They came back after 5 minutes and said, we're going to have to postpone the rest of the hearing. About 30 days later, the case was voluntarily dismissed. And I had an opportunity to speak to one of the lawyers, and he said, you know, he wasn't going to violate attorney-client privilege, but I was basically able to ascertain how that 5-minute conversation out in the hall went. It went something like this. Look, Nurse Jones, we know Dr. Smith is a real dirtbag because he moved all his money, you know, into this offshore structure. But the reality is it's going to be a very difficult, time-consuming process to go after him, to go after this money. And we'd be happy to do it for you, but we can't do it on a contingency fee basis. So if you want us to continue, you know, we're going to need a retainer fee of $25,000. At which point, Nurse Jones says, well, what about no fee unless you get money for me? Oh, well, that doesn't apply to, you know, international litigation. At which point, Nurse Jones threw up her hands and said, well, I'm not giving you $25,000. I don't think the case ever had any merit to begin with, right? So the point I'm trying to make is we weren't hiding, we weren't, you know, lurking in the shadows. No, we were very upfront. This is what we did. This is where the money is. If you think you can get it, have at it. All right. So the great Chinese general Sun Tzu wrote a book 3,000 years ago called The Art of War, and there's some passages in it that I really love as an asset protection lawyer. In one passage he says, the prevention of defeat lies in our own hands. Hence, the skillful fighter puts himself in a position that makes defeat impossible. So before he worries about winning the war, he wants to make sure he can't lose the war. And I like the same analogy in the legal and investment and business area, right? I, as the asset protection attorney, when I work with my clients, I want to make sure you can't lose the war and nobody can take away what you've worked your whole life to build and save and collect or inherited or however you got your money, right? After that, you know, there's lots of other people that can advise you on how to invest it and make more. That's not my job. I don't even do that for myself, so I'm not going to tell you. People always ask me, well, what do you think about this if you really want my opinion, I'll tell you, but opinions are like noses. Everybody has one, and mine's not particularly, you know, any better than anybody else's. But if we want to talk about asset protection, you remember the old E.F. Hutton commercial, you know, it's not what you make, it's what you keep. And that's what asset protection really is all about. Okay, so the first question, what is asset protection? Why do we do it? We've covered that. Second question, what risks are we protecting ourselves from? And what I've tried to do is divide the world of risks into 4 categories. The first is physical risks. People hate talking about physical risks. But the reality is, for most people, where you live and where you go to school, where you work, how you drive in a particular situation is frequently driven by physical risks or fear of physical risks. Okay? So it's around us. It needs to be taken into account. You know, why are we here at this Marriott hotel? We could be at a lot of places in Panama, but there's either real or perceived safety in being in a hotel like this, which is why a conference organizer would put a conference, you know, here. The second kind of risks I refer to as economic risks. And again, I'm not an investment advisor, so I'm not saying buy IBM or, you know, or sell Microsoft or do this or do that. But at the same time, when I sit down with a client, I frequently say, well, tell me a little bit about your assets. I want to understand your asset mix. And they describe they've got stocks and bonds and mutual funds, some real estate, you know, all the normal stuff. And then I say, well, tell me about the currencies in, you know, which currencies your investments are denominated. And I have to ask that question 3 or 4 times, and they look at me like I'm a Martian from outer space. And then finally their light clicks on, they say, oh, well, dollars, of course, right? And yeah, they might have a, you know, some kind of international fund, but at the end of the day, it's all still denominated in dollars. So that's fine, but what happens if your investment goes up 10%, all your investments go up 10%, and the dollar goes down 15%? Well, from an asset protection standpoint, that's not really a very good kind of strategy, is it? Now, I want to introduce the concept of gold, not because I'm a gold bug. I'm not. But I think we can all agree that gold is a measuring stick that governments cannot manipulate, right? An ounce of gold is an ounce of gold is an ounce of gold. And if you compare gold against every currency in existence from 100 years ago to today, first of all, most of those currencies aren't in existence, i.e. the Reichsmark, let's say. But the ones that are, the dollar, you can extrapolate, let's say, a Deutschmark to a euro, a pound. You can look at the various currencies that have been around 100 years. And when measured against gold, every one of those currencies has gone down between 91 and 99% against gold. So has the dollar gone up against gold, or has the dollar, has gold risen in value, or has the dollar gone down? And I would argue it's the latter. 100 years ago, an ounce of gold, you could go and a man could have a finely tailored man's suit produced. Gold was $20 an ounce. 100 years later, with 1 ounce of gold, you can go in, have a pretty nice suit made from a tailor for $1,300. So I would say gold is purchasing power. It's a constant. Dollar's gone down. Every other currency's gone down. But if we want to minimize the value, the potential loss, most economists will tell you that you have more upside and more stability by diversifying across a basket of currencies. So again, I'm not telling you next week the dollar's going to do anything, right? I don't know. I don't have a crystal ball. But I know over time, currencies are going down, and if I diversify my risk over 4 or 5 good currencies, I'm probably going to be in a better position. I'll give you one more quick example. I had a client come to me a few years ago, and they said, Can you look at this insurance product for me? It's by this big Swiss insurance company, and the broker told me that it averages 12% a year. It's all AAA rated, and it's 12%. Normally you think, well, geez, if it's super safe, how's it going to give me a 12% return? So I started reading through the document, and I found out what the formula was. The formula was the insurance product paid 1.5% in Swiss francs, and over the preceding 7 or 8 year period, the average devaluation of the dollar against the Swiss franc was 10.5%. And they added those together, and poof, there you go. There's your 12%, right? But you didn't have to be in that particular Swiss insurance product to get the 10.5. You just had to be in the Swiss franc. And in fact, I think, I've met some old timers that had money stashed away in Swiss banks and weren't getting paid any interest at all. And, if they had that over the last 30 years, their return on investment is pretty good. Just, when I was a student 30 years ago, I got 5 Swiss francs to the dollar. And then it went 4 to the dollar, 3 to the dollar, 2 to the dollar, 1 to the dollar. Then it was inverted. Now it's back to about 1 to 1, right? So the dollar has gone down 80% against the Swiss franc. Swiss franc's gone up 400% against the dollar. So those are the kind of economic risks when you start thinking about protecting wealth over a long period of time, you need to think about diversifying economic risks, things like gold, real estate, multiple currencies. All right. Then we've got taxation risks. And, everybody hates taxes. I will tell you again that, there's no magic fairy dust or way around them. When we talk about second citizenships, if you go the whole 9 yards and get a second citizenship and then expatriate, which means literally give up your U.S. citizenship, that's one legal way to end taxes, but very few people do that, right? So we have tax risks, but there are certainly ways that we can minimize them. I would guess most people in the room here have IRAs and 401ks, SARSEPs, KIOs, insurance products. Why do we have those types of products? We have them because we understand inherently that your money grows faster in a tax-deferred environment. In an insurance environment, It's a post-tax dollar going in. It grows tax deferred. It comes out tax-free. That's about the closest thing there is to magic fairy dust. But of course, for that to work, you have to die. So that's like not a great strategy for some people. But for people that are really trying to do true generational wealth transfer, wealthy families, insurance can play a big part of that. After taxation risks, the last risk is litigation risks. And, we all hate taxes. That's something the government imposes on us. Litigation is something we impose on each other. And the U.S. is the most litigious country in the world. It has been for many years. A new federal lawsuit is filed every 17 seconds of every minute of every day of the year. If you add state and local, it drops to about every 7 seconds. And, one type of litigation in particular that's particularly destructive to wealth is divorce. A lot of people don't think of divorce as litigation, but it's actually exactly what it is. And, if litigation's a war, then divorce is a civil war, right? Because you have two sets of lawyers and every expense that's happening is coming out of the same pot of money. A couple of years ago, I had an H.J. Hines executive in Pittsburgh come and see me. I'd known him for a while. His name was Tony, and he said, Joel, I have to tell you that my wife and I, after 35 years, have decided we're getting a divorce. I said, oh, Tony, I'm really sorry to hear that. He said, and I thought we could, come up with an amicable plan. We came down and we put all our assets on a sheet of paper, and I said, let's just divide these assets 50-50. And his wife said, no, that's not fair. She wanted 60%. She wanted to give him 40%, which he didn't think was fair. So he said, well, what do you think, Joel? And I said, well, let's see, Tony. If this goes to the whole way through, you're going to go out and hire a big law firm, right? You mentioned the law firm, big law firm. All the top partners charge $1,200-1,500 an hour. I said, now your wife, she's not going to hire a Mickey Mouse law firm, right? She's going to get another big one. Yep. Every time the lawyers get together, it's probably 2 or 3 or 4 from each side. Yep. I said, Tony, I'm not a divorce lawyer. I'm not a specialist in this area, but let me ask you one thing. You think 16, 18, 24 months from now, you're going to have more wealth, the same wealth, or less wealth by going through this process? And he said, well, I guess less wealth. I said, Tony, take the deal. He did take the deal. The last time I saw him, he was driving off in his red Mercedes convertible with his 27-year-old girlfriend, happy as a clam. So the point I just want to make is that asset protection planning is really a form of making sure that you don't expose your wealth to this type of destructive litigation. Even in a divorce, I had a situation not long ago where a couple that I had represented, both the husband and the wife, in creating an asset protection and generational trust, came to me and said, we're getting a divorce. I said, all right, let's get on the phone with the trustee. I got on the phone with the trustee. He said, well, right now, you're both beneficiaries. And he said, nothing will change after the divorce. We'll make an agreement that, instead of being together, you're separate, but you're both still entitled to 50% of the income and assets of the trust. Everybody agreed to that. Trust stayed in place. Not 1 cent was spent on litigation. All right. So I guess the first question is, do we have a level playing field in the U.S.? I think the answer to that's no. We all know that we live in a system that is pro-plaintiff, right? Because it's very easy to bring a lawsuit. There's a high nuisance value. The nuisance value of the federal lawsuit is about $50,000, I've been told recently. Okay? So if you want your tip from this conference, go home, find an excuse to sue somebody for under $50,000. Your doctor, your Walmart, your McDonald's, and probably their insurance company is going to settle because that's cheaper. By the way, that's a joke, so you don't have to do that. But the point is that the economic value is high. So with asset protection planning, are we trying to find that proverbial level playing field? I would say it actually does exist. The UK is a good example of a level playing field. Why? In some ways, it's like the US. Courts are open to everyone, right? But there's a couple of small distinctions. First, in the UK, there's no such thing as contingency payments. So you have to hire your lawyer, you have to pay your lawyer. Secondly, the whole British system is based on the concept of loser pays. So if you bring a frivolous lawsuit against me, I'm going to hire the best lawyer I can, and I'm going to fight you for days and weeks and months and years. And no matter how much I pay, in the end, you're going to pay because you brought the lawsuit against me unfairly. And lastly, if the plaintiff becomes indigent and can't pay, the plaintiff's lawyer is responsible to pay the costs of the defense lawyer. Do you think that might make the lawyers just a little pickier about which cases they take? Right? That would be a level playing field, but that's not what we're looking for. We are jurisdiction shopping the world to find the best jurisdictions that are pro-defense, not pro-plaintiff and not neutral. We're looking for jurisdictions like Liechtenstein, like Belize, like the Cook Islands, like Nevis, where it's very, very difficult to bring litigation in the first place, if not impossible. If I create a trust for you today in Belize and we put your assets in a trust and someone sues you tomorrow, they cannot go after that trust. Period. So that's the reason why people still like to use these types of jurisdictions. It's not, for most of my clients, it has nothing to do with taxes. It's about protecting their wealth, passing their wealth on in a very easy and way, however they want to their future heirs. We'll talk a little bit more about trust tomorrow. I have a whole presentation just on trust. So, why international asset protection? First, no recognition of U.S. judgments. What does that mean, no recognition of U.S. judgments? If you sue me in Texas and you get a judgment against me and find out I've got assets in Pennsylvania, you can take that Texas judgment to Pennsylvania courts and you don't have to relitigate the litigation. You just say, Pennsylvania courts, please enforce this judgment of the Texas court. That is based on our constitutional system. We have what's called the full faith and credit clause of the U.S. Constitution that requires the states to do that. So sometimes somebody comes to me and will say, oh, well, I set up my trust in Alaska, and I've heard that's every bit as good as an offshore trust. Oh, really? Well, you know, we have this constitutional thing called the full faith and credit. So when somebody gets a judgment against you in another state and brings that judgment to Alaska, and Alaska refuses to enforce the judgment, that's going to be a constitutional question that's going to go to the U.S. Supreme Court. And that hasn't happened yet, but I'm pretty sure when it does, whether it's a liberal court or a conservative court, they're going to strike down the Alaska law because states aren't allowed to they can't hold themselves out in such a way that they can defy the judgments of other states. That's what that means. But conversely, in other countries, that's not the case. Right? If you come down here to Panama with that same judgment from Texas, what do you think the courts are going to tell you here? They're going to say, well, you know, you can use that for toilet paper or whatever, but it's not worth anything here because there is no recognition or enforcement of U.S. judgment. Secondly, there's a bright line test, as I mentioned with Belize. It's a simple question. What came first, the lawsuit or the creation of the legal structure, in this case, the trust? It's very simple. If I created the trust today and you sued me yesterday, you might be able to bring the litigation. If I created the trust today and you sue me tomorrow, you won't be able to. Period, end of story. It's a bright line test. Conversely, in the U.S., we have what are called look-back rules that try to figure out what was the intent, what was in your mind when you set up a legal structure. In California, the look-back rule is 3 years. So let's imagine for a minute that you're an obstetrician and you deliver premature babies for a living in Los Angeles County. Does anybody in the room here think that doctor can go 3 years without getting sued? So what does that mean? That means California is saying, as a matter of public policy, a doctor is not allowed to protect their assets. That's what they're saying. So for that doctor, their only choice is to look at offshore because of this full faith and credit thing, right? They can't run off to Alaska or Nevada. They have to go outside the country to a place that's going to have a bright line test. Hey, I don't have a lawsuit against me today, creating this structure for my children, my grandchildren, and if somebody comes, no recognition of U.S. judgments. Thank you. Elimination of the statute of frauds. Again, that's a 500-year-old English common law notion that tries to get inside your brain and say, did you have a fraudulent intent, to defraud creditors? That's very, very difficult to figure out. Lastly, some places like Nevis have what's called a bond requirement that says, yes, you can sue me, but you have to place a bond with the court that the court's going to estimate the value of the costs of, let's say, the lawyers or the litigation. And if you lose that litigation, then again, it's going to go to the winning side to pay their costs. So it just ups the ante in what you should try to do in terms of suing somebody. Now, I happen to come originally from Pittsburgh, and I always like to work a Pittsburgh slide into my presentation. I hope there are no Minnesota fans in the room, but this is a picture from Super Bowl IX. And that was the famous steel curtain defense right there. We've had a lot of good teams lately, the Steelers, but the most famous teams from the 70s and early 80s had this steel curtain. And actually, in 1969, when the Rooney family hired Chuck Noll, the first person he went out and drafted, he had the #1 draft pick, he went out and drafted a guy by the name of Mean Joe Green. I'm sure most people have heard of his name, and he became the centerpiece of the steel curtain defense. And it was interesting because up until that time, when the teams came out on the 50-yard line before the game started and flipped a coin, now there's different strategies. But at this point in time, if you won the coin toss, the winning team always did what? Took the ball. They always took the ball, right? We want to put our offense out there. We want to score. Well, Chuck Noll, by 1970-71, had a tremendous defense, and he had a very mediocre offense because guys like Franco Harris and Terry Bradshaw and the offensive guys hadn't really come into full stride. But he had this steel curtain defense. So what he did was he was the first coach that always deferred. Why did he defer? In an interview he said, well, we had an exceptional defense and only a mediocre offense. And I wanted to prove that no matter what the other team did, that they couldn't run and they couldn't pass the ball. And that would have a demoralizing effect, and then I would hope that my offense could, eke out a few points. And in Super Bowl IX, by the way, if you ever want to Google it and look, the halftime score was the lowest ever in Super Bowl history. The halftime score was Pittsburgh 2, Minnesota nothing. Now, how do you score 2 points in football? Safety. Who scores the safety? Defense, right? So I just love that analogy because we want to do the same thing with asset protection. We want to intimidate the other team. I don't know what kind of offense each of you have. I hope you have an exceptional offense. But even if you only have a mediocre offense, like the Steelers, we want to make sure that nobody can come after you and get what you already have. So there's great jurisdictional benefits going offshore. Tax, I mentioned earlier today, the foreign earned income exclusion. That's a particular section of the tax code. In other countries, like the Europeans, they tax you based on residency. So if you're a French citizen and you don't particularly like the 75% top marginal rate, you can move out of France to some other country, let's say Belgium, where the top rate's only half as much, and that's what you're going to pay because it's based on residency. But the U.S. is not that way. The U.S. taxes you based on citizenship. So unless you expatriate, you're always going to pay U.S. tax. But there is this section of the Internal Revenue Code, Section 911, that deals with the foreign earned income exclusion. In fact, this is last year's slide, so it has to be updated. It's a few $1,000s higher. Are we going to talk about this, Leaf, in the tax? Yeah, okay. So I don't have to spend any time on that. But there are real tax benefits. And again, if you can save, the taxes on $115,000, that's a real benefit. That's asset protection. Privacy benefits, we want to set up our structures and our assets in places where they still have real bank secrecy. You're going to hear from somebody like Peter Zipper tomorrow or the next day, where the only person that can get information about your account is you. In the U.S., we have bank secrecy laws, but it's like the world of the Mad Hatter because what our bank secrecy laws say is your bank has to provide your information to the government anytime it asks for it, and it has to keep the disclosure secret from you. How about that? Well, there's other jurisdictions where you still have real bank secrecy. Then you have corporate secrecy, meaning that there's no public registry that shows that you set up a company or shows that you set up a trust, okay, or shows that you set up a foundation. Those are the kind of jurisdictions we want to use. Not to help you avoid or evade your tax and reporting requirements. Heavens no. In this day and age with FATCA, the transparency that exists around the world, forget all that, right? I'm assuming that all of you are going to comply with the laws and pay your taxes. But that doesn't mean you want every Tom, Dick, and Harry or plaintiff's attorney or ex-spouse to be able to go on a fishing expedition to find out, that you have assets here or there. Estate benefits, I think for a lot of my clients, it's one of the main reasons why they decide to do their asset protection planning and estate planning offshore. Elimination of the rule against perpetuities. It's an English common law concept that says you can't leave your money into perpetuity. You have to leave it to your children, your grandchildren. There has to be what's called a life in being. Okay? But other jurisdictions have said, well, why is that? It's your money. You paid your taxes on it. Why shouldn't you be able to do whatever you want with it? What if you want to leave it to your children's children's children for the next 1,000 years and they can only access the income or whatever? You should be able to do that. And as a practitioner, I particularly love the flexibility because my job is really to understand what the client's wishes are and then turn that into the final finished document. And I don't have to worry like, oh, this jurisdiction doesn't allow this, it doesn't allow that. So it gives you maximum control from beyond the grave. That means, if you say, my kids get a certain amount of money, but only if they earn a certain amount of money on their own, you can do that, right? You can say, I don't want to create trust fund babies that are going to sit around and get drunk and high at 3 o'clock in the afternoon on the family sailboat. You're only going to get money if you go out and earn it, right? If that's what you want to say, then my job as the lawyer is to make sure that works its way into the document. Life insurance, as I mentioned, I could give a whole presentation just on that. I really wish we had time for it because it's very interesting. Not because I'm in any way a life insurance salesman, I'm not. But it's one of the last true loopholes in the tax code that allow for assets to build up tax deferred and then go tax free, the distributions. So that's very interesting when you're trying to get real generational wealth transfer. And then avoiding probate and forced heirship rules. Most of the U.S. states, with the exception of Louisiana, are common law states. We don't really have forced heirship rules, but lots of other countries, France, for example, mandates you have to leave X percent to your wife, X percent to each child. It doesn't matter whether you're estranged or whatever. And All right. So I'm going to finish. I don't think I'll have time for the story of two kings, but maybe we'll bring that up in one of the other sessions. But I want to finish here with the most common structures, most of which we touched upon. But I just want to touch on them again really quickly. First, we have trusts. Trusts can be divided into two categories, revocable and irrevocable. A revocable trust is not an asset protection vehicle. It's a probate vehicle, period, end of story. So if you have what's called a revocable living trust, that's great. It's going to help your assets, going to shield them from going out and people knowing what you had at your death, but it's not going to save you if a lawsuit comes along. That's an irrevocable trust. Again, we'll talk a lot more about trusts tomorrow. Foundations are the civil law version. Napoleon didn't like some of the effects of common law trusts, and so in the Napoleonic Civil Code, he didn't allow for trusts, but eventually they sort of engineered a way around it, and that's foundations, which do largely the same thing. Civil law country like Panama, it's a great jurisdiction for foundations. All different types of companies, you know about what a company is, but some people think they get the same benefit as they would from a trust, and that's not true. A company is a shield that you hold out in front of you, okay? And somebody's shooting arrows at you, and you're using that shield to block the arrows. But what if somebody sneaks around the back and they capture you? How is that shield out front protecting you? It's not. If they get at you, the company is just one more asset that you hold, even if it's an offshore asset. Somebody gets a judgment against me in the States and I have an offshore company, they'll be able to get that asset too. A trust is a separate legal juridical person. You won't be able to get that asset. Insurance we talked about. Non-reportable foreign assets. It used to be at a conference, we'd spend a lot of time talking about the non-reportable foreign assets, what you could own that you didn't necessarily have to report. That list has gotten smaller and smaller and shorter, and there's really only 2 assets left. And there are groups of people that love when I mention these. I have no vested interest in either. I'm just telling what the reporting requirements are. The first one's real estate. So whether you own a condo in Panama or a beach lot in Belize or whatever you own, the ownership itself is not reportable. That doesn't mean the income's not, right? If you have income coming from that property, you certainly have to report that. But just the ownership and the existence of that property is not reportable. The second non-reportable asset is in the precious metals industry, and it's bullion. It's physical metals. I'm not talking about ETFs or Perth Mint certificates or any of that. I'm talking about actual physical metals. All right? Now, I can understand why real estate's not a reportable foreign asset, but why metals aren't, I don't know. I have no idea. All I can tell you is probably some IRS agent has a bunch of his assets in gold in Switzerland and he didn't want to have to report it. So they're actually in the rules for foreign bank accounts. If you read through the questions and answers, someone actually was smart enough, Leif and I used to disagree on this point, but somebody was actually smart enough to ask the question, is gold a foreign reportable asset? And the IRS answer is no. And then they have several pages explaining why and when it could be. But bullion metals in physical form are not reportable. Foreign residency and citizenship, it used to just be one squirrely guy in the back of the room that wanted to talk about that. Now it's very widespread. Everybody wants to talk about it. What can they benefit from having a foreign residency, foreign citizenship? Again, very few people take the ultimate last step, which would be expatriation. I think last year about 8,000 people expatriated. We had 1 million immigrants and 8,000 left, so we're not going to run out of people. But a lot of those people are folks that are wealthy, entrepreneurs. A lot of those types of people have left and are leaving because of the tax code system we have. And lastly, debt. And debt's not a structure, but it is certainly a strategy. And I'll finish with that just to say that imagine, let's use the obstetrician out in California again, right? So he's got $1 million home, and that's going to be a very juicy asset for a plaintiff's attorney to go after. So what if he created a trust, and instead of trying to transfer the domestic property to the foreign trust, he just got a loan for $950,000 and took the cash out and put the cash in a bank like in Belize, put it in a CD, took the interest from the CD to service the mortgage back in the States. Now, anybody here think that if you sue that doctor and let's say Bank of America has the mortgage for $950,000, anybody think they're going to jump ahead of Bank of America to get that? No, right? So there's times when debt can actually be your friend. It can help protect you. And I'm getting the axe from the back. I wish I had a few more minutes, but I want to thank you. I want to thank everybody for their attention. I also want to mention that on the last morning, on Wednesday, from 7 to 8, there's an optional question and answer where if you heard things, whether it was from me or someone else, and you'd like to have it clarified, I don't know if that's going to be live streamed, but it'll be a chance for you to just ask questions. If you don't want to come, you don't have to, but if you have questions that you didn't get answered throughout the week, come and we'll do our best to try to help you answer them. So thank you very much for your attention. I hope you enjoy the rest of the conference.